Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen.
And I'm Diana McBey.
Welcome to Hull on Estates. You're listening to episode number 664. Hi, Diana. How are you?
Good, how are you?
I'm good. Thanks for finding this case for us. I actually found it to be really interesting because it's a case from Saskatchewan on the administration of estates and the removal of estate trustees. And I was actually quite surprised to see just maybe how different the estate administration laws are in Saskatchewan as opposed to Ontario. So maybe you can give us a bit of background, maybe how you came across this case, the name of this case.
Yeah, so I came across this case originally. I was writing a blog and I searched up interesting Canadian estate cases that were recent. And this one popped up. It's Nagy and McBey. And it's a really interesting case. The deceased, Blanche, she passes away in November of 2012. And she has 7 children included in her will out of her 9 children. So it's a pretty big family. So lots of beneficiaries. And it's a relatively small estate. But her estate is going to be divided equally between 7 of the 9 children. 2 of her children are made her executors. One, Joanne, and the second is Dennis. Dennis is one of the 2 kids who will not inherit under the will because of previous money he got from his mother earlier on in life. So Watch dies in November of 2012. Joanne and Dennis just sit on the estate administration for 8 years. They eventually apply for letters probate in February of 2021, which are approved in April of 2021, after which point they open the first estate account with the bank.
So maybe let's break this down a little bit. It is interesting in this case, how the estate plan ended up being, because there are 9 kids. 2 of them don't inherit, and one of the 2 who doesn't inherit is actually one of the estate trustees. Very little was done, and actually by the time this case is heard, one of these kids have also died. He is a beneficiary, but he didn't leave a will, so his interest in the estate ends up going back to his siblings. He also didn't have any kids or a surviving spouse, but Joanne and Dennis, you said that they didn't even apply for probate until 2021. Quite a bit of time between death from 2012. But all the while in the background, Dennis has actually been living on the family farm, hasn't he?
He has, and he's been farming it for that time. And problematically has not kept accounts of how much rent he should be paying to the estate, what's coming in from the farm profits, what he's spending money on in expenses for running the farm. And that actually becomes one of the problems in this case, is the accounting and how well it's being kept track of.
Right.
How well it's being tracked in the accounting.
Yeah. And it's kind of the classic bottleneck with estate administrations is, it might be easy if at the end of the day when your parent is gone, all they have left are bank accounts, so that the moment you get probate, you've paid the taxes, then it's very easy. You're just sort of sending money from a bank account. But for this one, mom actually died with the bulk of her assets in land, very little in the bank accounts. And here we have Dennis actually living on that land, for less than a decade, really, having the benefit of it while everybody else is waiting and not really paying rent. And like you said, not really keeping track. And so this is why it's the classic estate trustee removal case. It's taken a long time. One of the estate trustees have had some benefit that everybody else didn't get to have. And so when you read the facts, it's not surprising that this ended up in court and the parties couldn't resolve it leading up to the decision. the part I was actually the most surprised by is sort of like how the law in Saskatchewan like really like comes to play here. Like their statute is really clear in spelling out like this test for estate trustee removal. And it's under the Administration of Estates Act in Saskatchewan under Section 14.1. And a removal occurs when the court is satisfied that the estate trustees have, one, failed to administer the estate in a reasonable and prudent manner, and two, their removal would be in the best interest of those persons interested in the estate. That to me is like off the bat, like very different. We don't have this type of like wording here in Ontario. Even the idea that you fail to administer in a reasonable manner as well as in a prudent manner, and how just sort of in a sense how that subjective that can be, and I'm using subjective in like those quotation marks because reasonableness is not necessarily supposed to be that subjective, but you know, here in Ontario, it's a really high watermark test for the removal of an estate trustee, because at the end of the day, the court is interfering with the wishes of the testator, right? Like for there to be an estate trustee appointed under the will, it's because the testator had thought long and hard about who he wanted or she wanted to have as their estate trustee. And it's as intrusive as just like swapping out the name of a beneficiary, and for the court to be like, hey, like maybe we shouldn't give that $20,000 to like this person that's named. Let's give it to somebody else. Now, like that's obviously like a crazy exaggerated example, but in a sense, you're kind of undoing something like the testator like had done for him or herself, right? Like that's what they chose. But the fact that like removals are, you know, something that hangs over every estate trustee's head in every single province, sort of like anytime during their administration, is because you have to be accountable to the beneficiaries. You have to be accountable to the court for the administration of the estate. And you can't be like just this like be so terrible and have like no recourse in your removal, because then at that point like you'll have like full impunity, right? Like, and so in Ontario, again, it has to be like a case of absolute clear necessity before a court will remove an estate trustee, and that's because of the court's deference to the testator's wishes. And there needs to be the only clearest of evidence to show that there's no other alternatives that can be done to ensure that this estate is actually going to be administered properly. So if there's any other alternative, like appointing like an extra estate trustee to like act, appointing even just like a trust company to come on to help, but not to be the estate trustee, but just to like assist, like just like smaller stuff like that. That is like maybe like what the Ontario courts might be like open to. And then it considers the welfare of the beneficiaries, which is also a little bit different in Saskatchewan because it's the best interest of those persons interested, which kind of in my Ontario mind opens this up to like maybe like creditors trying to remove an estate trustee. Whereas like in Ontario, you couldn't have that. So let's fast forward a bit, because I think like in this case, it's really interesting because of like, there's like no other course to follow. Because by the time this actually got to the court, I think these two estate trustees did get their act together. What did they end up doing by the time it's 2021, Diana?
Yeah, so basically their whole claim is that they weren't prompted to do anything. They didn't know they had to do anything until 2019. As soon as they did, they got on top of it. So they apply for probate in 2021. They get it in April 2021. And then they go through an estate accounting, which the court ultimately determined was unacceptably vague. But they sell the farm, which has a caveat that Dennis will try to buy back part of that himself. And they distribute more than $300,000 in distributions before this court case actually comes to be heard. And another thing that's interesting about this particularly is that several of the siblings at this point have signed a revocation and renunciation and consent because they don't want these two estate trustees running it. And what's particularly interesting of that is that one of the people who signed this is an estate trustee, Dennis.
Yeah. He was ready to let it go, but I think Joanne, his counterpart, wasn't. So yeah, this one, like, they were actually pretty close to the end. Like, I think if Joanne was like, the hearing date was a little bit later, maybe Joanne would have like done even more by that later point. Who knows? But, just sort of some of the ways in which the court ended up critiquing Joanne and Dennis all had to do with those like original early delays, but it's very much part of what the statutory expectations are for the administration of an estate in Saskatchewan, which is, again, like what caught me like by such surprise, because in Saskatchewan, their Estate Administration Act actually gives a requirement for estate trustees to apply for probate within 60 days of death, failing which they kind of like lose their sort of like right to apply, and then the other people can apply, which to me was like, well, that is a very tight time frame. And there's also an additional time frame after that where they have to give a full account of the administration of the estate within 2 years of obtaining probate. And like the way it's full account of the administration, does that mean like it has to be a full account of what you did in the 2 years? Or like you're basically saying like you need to be done by 2 years and you need to give that full accounting within the 2 years. To me, it's actually like very onerous, especially with like, the complicated estates that like you were talking about, Diana, early on. And I'm sure like there are other parts of the statute that has like sort of like more relief for like estate trustees, maybe like more caveats and things like that. And maybe like just the judicial interpretation of it is like generally like less strict than maybe what we see in like the Nagy estate. But at the end of the day, if you really haven't been doing anything, the beneficiaries are intent on complaining and getting you removed until you are absolutely removed, that's when all this stuff will end up adding up, and the outcome's the outcome. But yeah, this is actually really good even for like everybody in Ontario to have in mind, because maybe if Saskatchewan can do it this fast, like we gotta get our butts in order. All right, so that concludes our podcast. Until next time, I want to thank you for listening. I'm Doreen.
And I'm Diana McBey.
Should you have any questions, please email us at info@hallandhull.com or contact us through the contact page on our website. Our website will have like the full legal citation and name for this case so that you can pull up and read it yourself. Thanks, Diana.
Thank you so much, Doreen.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hallandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.